Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to cover something that was just recently in the news here. No charges for Edmonton police officer who fired service pistol at another officer. Now, normally this would be a Scotch video, but as you know from my last video, I've been having some health issues lately, so no Scotch for this one. But, so I'm not going to go through the article sort of word for word. I'm going to link it so that you can check it out and see the full content for yourself. But basically, they've decided that they're not going to file charges for this officer. And what was going on here is that they were doing training with a laser, I'd say laser weapon, except it's not a weapon at all. It's a laser training tool. And you can see here there's an image that shows on the left the laser training tool, and then on the right, the service pistol. Now, in the course or after this training, the officers were sort of screwing around. They were playing around and shooting each other with the laser guns. And in the course of playing around and shooting each other with the laser guns, one officer ended up going for the non-laser gun and fired a round at another officer. Now, thankfully, it didn't hit the other officer. It hit a battering ram and caused what they described as substantial damage to the battering ram. I suspect that battering ram is not going to be usable. It's going to have to be replaced. I have no idea what a government battering ram costs, but I'm guessing it's surprisingly expensive. And so this was referred to ACERT for charges and then later went on to the Crown. It was tested. We can see here the Glock pistol was seized for testing. It was determined the gun was functioning properly and the amount of pressure needed to pull the trigger was within the normal range. So the fault is not with the gun here. We also see the officer declined to provide evidence or a statement to investigators. And that's his charter right. You know, he's got a right not to provide evidence to be used to prosecute himself. But this provides an excellent illustration of what the police do when they're facing, when they're in the soup, which is that they know time to shut up. So if you're ever facing charges or in trouble, do what the police do and shut up, because it's worked really well for the officer here. So, the officer is not being charged. If he talked, that may well have been a different thing. So they note that the involved officer deliberately pulled the trigger when he pointed and fired the firearm, but there's a question about the intent, and ACERT determined that there were 3 limited conclusions to make on what occurred. So these are the possibilities that they determined. One of these things must have happened. And so one, that the officer mistakenly raised his Glock pistol, believing it was the laser training tool, or that he knowingly raised and fired his Glock but believed it was unloaded or loaded with non-lethal ammunition, or that he knowingly pulled the Glock and intentionally fired the gun in the direction of the other officer. They say the first 2 scenarios would be indicative of actions that would fall closer to an accident or mistake with no intent to cause harm. The third scenario would constitute the highest level of both moral and legal culpability. Yes, I agree. It would be incredibly morally culpable if he was intentionally shooting at another officer. So, however, and I think this is the right conclusion here, they find that there's no evidence that indicates that he was actually trying to shoot his fellow officers. This doesn't seem like he just suddenly decided that he was going to straight up murder another guy for no real reason. But they do find that there were basic common sense tenets for handling firearms that were ignored or violated. And I'll quote further, they say, at best, the involved officer's handling and use of the firearm fell far short of the specific and rigorous duty of care expected and established by Parliament. That no one was injured or killed was nothing short of exceptional good fortune. And quite frankly, I agree. This could have gone really badly. So the director of ACERT actually believed that the evidence provided sufficient grounds that it could constitute a criminal offense and sent it on to the Crown Prosecution Office. And the Crown determined that there was a reasonable likelihood of conviction. However, they determined that it was not in the public interest to proceed with prosecution, and so they're not charging the officer. And they say there's absolutely no doubt that a different decision would likely have been made had anyone sustained injury or died. Now, I'm just going to go ahead and say I don't agree with with the decision here, and I'm a little concerned by it because, quite frankly, uh, at the point where they're engaging in horseplay with, fake or toy or anything like that firearms in the presence of real firearms, loaded or unloaded, but in this case, loaded, that's extremely dangerous behavior. If I went to an airsoft game and brought a real steel pistol with me, like an actual, a Glock handgun, as in this case, and, let's assume that I had, the proper authorization to transport and all of that stuff. So no issues with the fact that I brought it there. But, if I was there with a substantially similar gun and had an accident, I'm pretty sure I'd have been charged. Like, how do you not get charged for the simple carelessness of horseplaying with these fake guns while you've got the real thing around? And although there's, I'll bring it back here, there's some substantial differences between these two designs, but they're not enough that, you can't imagine a mistake being made here. I will tell you that I have seen charges being laid for careless use of a firearm in all sorts of situations where negligent discharges have happened, notwithstanding the fact that no one's been injured. In many cases where the evidence was substantially less than this one, because here I think, I don't think the Crown is ever going to be able to prove that it was an intentional shooting. But when we look at the three possibilities, possibility 3 of the intentional shooting is, of course, criminal. If he's trying to shoot his buddy, that's obviously criminal. Possibility 2, that he knowingly raised and fired his Glock but believed it was unloaded or loaded with non-lethal ammunition, is still plenty criminal. That would be pointing a firearm. And, because you can get a conviction on pointing a firearm whether or not it's loaded. But it's also really careless because, if he thinks it's unloaded or loaded with non-lethal ammunition and he's wrong about that, how does that happen? How and what non-careless situation is there ever outside of self-defense for pointing a firearm at another human being and pulling the trigger? The third scenario, that he believed it's the laser pistol, is still, in my view, careless because they're just sort of farting around here with these laser pistols in the presence of real firearms. What did you think was going to happen? Who couldn't see the potential for that to go really, really wrong? You're not looking, you grab the wrong thing, and you pull the trigger. They point out that there's differences in weight, that there's differences in texture, that there's various other things. But those are easy to miss. And I think the very act of the horseplay with these laser training pistols in the presence of the real gun is quite arguably, and I think, this is a situation where quite possibly it should have been taken before a judge as too careless. Now, they say that there's reasonable likelihood of conviction. So they agree with me that there's a likely possibility that they could get a conviction here, but they're saying there's no public interest. And I kind of find myself wondering about that too, because I wonder how much the public interest here is the fact that if he gets a conviction for the careless use of his firearm, that he's likely to lose his job and would not be able to function as a police officer anymore. And while that's unfortunate, I'm sure they spent a fair bit of money in terms of training this constable. And, who I'll note, they haven't actually released the officer's name. So all we have is the involved officer. So again, a high level of privacy for this officer, but not for you or I. The news, if it was about you or I having this sort of incident, would almost certainly have your name. But so going back to the thing here, I get that they probably spent a bunch of cash training this officer, that this officer is probably a good officer in other respects. This probably isn't somebody with a heap of disciplinary issues, who's been causing trouble and so forth. But this is an officer who showed what seems to be really poor judgment under the circumstances, and really poor judgment in a way that calls into question, is this somebody who we want to place this high degree of trust on, that they're going to be walking around and with weapons in society? When we say only the police are allowed to carry handguns, in theory, that means that they should be held to an absolute exacting standard, not, oh, wait, well, the guy just had an oops that was entirely avoidable with, live ammunition and almost killed a fellow officer. Like, if the public interest is we really want to make sure that this guy's wandering around in public with live ammunition, I'm not sure I see it. I can see that it would be very easy, frankly, to come to the opposite conclusion, that maybe the public might be better served if we train somebody else who's going to be a little more careful. So when we look at this in terms of the public interest, one thing that I think is relevant is, what would we want to get on sentencing? And so what sort of outcomes or beneficial effects for society would we be looking at? In particular, I think of deterrence. Now, deterrence comes in two flavors. The first is specific deterrence, which is by imposing a punishment, we're going to prevent this specific person from committing further offenses. Now, I don't think that's a major consideration here, and I'll sort of explain why. I don't think that there's a punishment that he would reasonably get that is going to be more of a specific deterrence than simply the event itself. Because assuming, and I assume that this officer is not some sort of psychopath or crazy person or anything like that. I assume this officer is a decent human being who that was probably one of the worst moments of his life. The old adage is that there's, the two loudest sounds on the gun range are a click when you expected a bang, and then the one that's a little higher is a bang when you expected a click. This bang when he expected a click is, I think, going to be a moment that is etched into his mind. And quite frankly, if that moment is not enough to say you need to step up your safety game, I don't know what would be. I think that the next step after that would be that, somebody should not be anywhere near firearms. Because if that's something that you could do and then just be like, no big deal. Oh, that's a worrying thought, right? But I think this is a time for general deterrence. And what general deterrence means is sometimes by punishing somebody, you can set an example for other people. Now, often we use general deterrence in situations that, in my view, aren't really going to have that effect. If somebody steals a sandwich because they're starving and, we punish them really harshly, we're probably not actually going to have much success in convincing starving people not to steal sandwiches, because they have other motivations that are more powerful than any punishment we can impose. But general deterrence starts making a lot more sense when we start looking at, members of organizations or places where there's planning. Now, this isn't a situation where I think there was planning, but we're talking about a police force, and a police force that's going to have training and so forth. And I think there's a lot of potential for general deterrence, because if they say, hey, listen, here's the rule, you don't play with these things. These are not toys, because, hey, Officer Bob thought they were a toy, and there's a reason Officer Bob isn't an officer anymore. That has tremendous general deterrent effect. So there is a societal benefit to that. Now, unfortunately, that's not great for, Officer Bob. And again, I'm just making up a name here. We don't know his name because they haven't released that. But it might be better for the public, if the police are not being cavalier with, with their equipment. So I think that there's, different considerations. I'm also going to say, I don't know what was going on at the Crown's office when they said, hey, we're not going with charges here. There could be all sorts of things I'm not seeing, I'm not thinking of. But this is sort of my armchair analysis. They may come to a very different conclusion, and in fact, they have. So, and I'm also going to say I'm not sufficiently this isn't one where I'm like, their decision is obviously wrong. I can see that their decision is within the sphere of reasonability. So if I were a judge and this were coming to me as an administrative decision where, and I'm imagining some fictional world where this was reviewable as an administrative decision and, the standard is reasonableness, I'd probably say, I don't agree with your decision, but I don't have enough here to overturn it. And I'm sort of speaking admin law speak here, but essentially I'm saying I don't think it's so wrong that it would be something where, if I was, the Crown's boss of whoever made this decision, I'd probably be like, I don't like the decision, but I'm not going to go over your head. I'm not going to flip this decision. I'm going to accept that you're probably making the right call with what you have. I still don't have to like it. That's, I guess, the distinction here. I don't like this decision. I feel like I probably would have gone a different way. Anyway, I wanted to share that with you. I also feel that, if I had had, an accidental, I say accidental with the heaviest of scare quotes, because quite frankly, this was not just an accidental discharge. This is one that very much could have killed somebody. Some people take the view that there's no such thing as an accidental discharge outside of, some sort of mechanical failure or something along those lines, that that simply the fact that a projectile was discharged unintentionally necessarily means it's negligent. I'm not sure I'd go so far. The rules of gun safety are overlapping for a reason. They assume that people are human and that they may break one rule at some point. And they're written in such a fashion that if you are only breaking one, you're unlikely to seriously injure or endanger or kill anybody. But here we see multiple rules violations, and more importantly, and I think this is a bigger deal, is that, without even sort of going into the 4 rules of gun safety, just fundamentally, horseplay around firearms is entirely inappropriate. These are not toys, and so long as a gun is present, it is not a time to be screwing around. Take this seriously. This is, if you want to goof off, that's fine. Just make sure that you are absolutely certain that all the guns are locked away beforehand and that, there is no possibility for this kind of thing to happen. So I think this is a major failure. Anyway, I'll cut it off there. As I said, I'll link the article in the description below. Thank you for watching. Please like this video. Please share it with your friends. Subscribe to see more content. If you want, you can also hit notifications so that you can see these videos as they're posted. I also want to thank my Patreon subscribers at the $50 level: D. Moe, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Kyle Martin. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt, as well as the $10 supporters who will be in the crawl immediately following. Thank you for watching, and I hope I've armed you with knowledge.